Good day, everyone, and welcome to the Q3 Legal Issues Committee webinar. This is going to be a very jam-packed webinar. We have a lot of information today. Joining us first to address qualified written request and call recording update is Loren from Severson and Werson. COVID-19 has not only affected our customers, but affected us. And we're involving a lot of return to work issues now, very important subject. So Todd Wulffson will address that with the CDF Labor Law. And then finally, where COVID-19 has had a lot of impact is in the area of servicing. A lot of developments there in terms of the agencies, Fannie, Freddie, and also the Cfpb's final mortgage servicing rule. Sandy Shatz, from McGlinchey, Stafford, and my colleague Reid Herlihy from Ballard, Spahr, will be addressing those very important issues. Just quickly on the CFPB update front, I don't want to take much time since we do have a lot of content. The Bureau did issue Juneteenth guidance. It took them about 2 months to do it, about 2 months too late. The basic guidance for the rescission waiting period and the TRID rule waiting periods and the TRID rule mailbox rule is if the applicable period started on or before June 17th, the day the Juneteenth became a federal holiday. If the period started on or before that date, then Saturday, June 19th was a business day, but you could voluntarily have treated it as a non-business day. If the period started June 18th or later, then you had to treat Saturday, June 19th as a non-business day. That's the basic guidance that they issued. If you have any questions regarding that, you can contact Dustin at CMBA and we'd be happy to address your questions. But with that, I'd like to start it and turn it over to our first presenter, Loren on qualified written requests and related trends and litigation. Loren, please take it away.
Thank you, Richard. Hi, everybody. Happy Friday. Thank you for joining us. I'm going to present on QWR, RFI, the trends and litigations, because as the title suggests, there has been an uptick over the last year or so in QWRs generally, but also more specifically, Dustin, if you want to flip over to the next slide, there's been a trend of these QWR qualified written requests, or RFIs, requests for information, which we'll go over in a second, that specifically target call recordings. They're largely from one firm. It's a means of generating litigation, in particular class action lawsuits, and so we wanted to flag that for you and generally talk about them. But also just across the board, QWR have been around for a very long time. They've been creating litigation for a very long time, and although the volume has gone down, particularly with respect to the foreclosure crisis, the 2010 through 2014 litigation era, it's gone down, but they're still here. So we're still seeing them today and wanted to touch base on them. Dustin, you want to flip over? So I thought a good idea would be to level set and just briefly review the statutory framework for both QWRs and RFIs. RESPA has long authorized borrowers to submit qualified written requests. Like I mentioned a minute ago, these have been around for a very long time. Folks are probably all very familiar with what the requirements are for a valid QWR that then necessitates a response from the servicer. Briefly, it must be in writing and on something other than a payment or a payment coupon or some other medium provided by the servicer to the borrower. It must include the borrower's name and account information or other information that would enable the servicer to determine what account it is in relation to. And then importantly, it needs to include a statement of the reasons for the belief that the account is in error, or describe the information sought in detail. And I have this underlined because it is important. That relates to the servicing of the loan. And servicing of the loan is a term of art in RESPA, and it's defined specifically as relating to scheduled periodic payments, including amounts for escrow accounts, and making the payments of principal and interest and such other payments. So in short, a valid QWR needs to relate to the servicing of the loan, which is a term defined in RESPA as payment processing. It's a very narrow scope. Upon receipt of the valid QWR, the servicer must acknowledge receipt within 5 days, and then generally respond within 30 days, subject to one extension, and either correct the issue that's been flagged, provide the requested information to the borrower, or explain in writing why the information is unavailable. And then finally, you have to provide a name of an employee who can further assist. So let's then talk about the RFIs under Regulation X. So obviously in 2013, CFPB amended Regulation X, which implements RESPA by enacting the mortgage servicing rules. Those are effective in January of 2014. They're quite comprehensive. They do a lot, added a lot. In pertinent part here, they created the notices of error, the NOEs, and requests for information, which we refer to as the RFIs. I'm just focusing on requests for information and QWRs for this presentation because they're what appear to be most problematic. Typically, you get a submission from a customer that will kind of be like a QWR, NOE, RFI hybrid. And it's the requests for information and documentation that we're seeing often leads to disputes and litigation. So what is an RFI? Almost the same as a QWR, at least it appears so on face. It needs to be a written request that identifies the borrower and the loan or account number, or has information that enables the servicer to identify that account number. And importantly here, though, the big difference between a QWR and an RFI is the scope in which the information may be requested. So the borrower's loan account, it states the information the borrower is requesting with respect to the borrower's loan. Backtracking real quick, the QWR has to relate to, quote, the servicing of the loan, right? Here, an RFI just has to request information with respect to the borrower's mortgage loan. Much more broad. At least it purports to be on its face pursuant to the regulations. However, it's important to know that some courts have applied the narrow definition of servicing from RESPA to Regulation X, including several courts in the Ninth Circuit. There's a split of authority, however. So on the other hand, other courts have rejected that approach, and they recognize that QWRs are just one type of permissible request for information, and that Regulation X has its own rules and can expand the scope of an RFI. So as I have here on the slide, the RFI statute specifically says that a QWR in compliance with RESPA also qualifies as an RFI. And another important limitation here implemented through Reg X is that servicers have the discretion to designate an address that a borrower must use. So oftentimes a servicer may receive a QWR/RFI to some sub office or something like that. If that's not the address that's designated, then it's arguably not a valid request. So upon receipt of a valid request, the servicer must acknowledge receipt within 5 days, and then again, generally comply within 30 or 45 days unless an exception applies. So let's briefly go over the exceptions that are included in Regulation X. So even where an RFI satisfies the statutory requirements, the servicer may not have to comply if one of several things exists. The first is that the information is simply not available. In that case, a reasonable investigation has been conducted, but the info is not available to the servicer. And availability is defined in the official interpretations to Reg X. I have it quoted there. It's basically just it's not in the servicer's control, or it cannot be retrieved in ordinary course of business through reasonable efforts. And that latter one we see as a justification for not producing information. Oftentimes, if like a servicer's electronic systems of record don't have the requisite functionality to, like in this example, we'll go over in a minute, pull call recordings, especially from a specific date or specific range. So technological limitations, for example, might be a basis for saying that the information is not available. Assuming the information is available, you then may still have other reasons why you don't need to produce it. And those are delineated there. It's duplicative of a prior request. It seeks confidential, proprietary, privileged information. The request seeks irrelevant information. The request is overbroad or unduly burdensome, or it's untimely. I'll note though, even if one or more of these exceptions apply, the servicer still needs to provide notice to the customer, explaining why it's not going to comply with the request. So there's been instances in the past where a client has determined that, oh, you know what, this request is extremely overbroad, or it's, you know, whatever reason, they're not going to respond, and then they just simply don't respond at all. And that in itself is a discrete violation of Regulation X. So you need to make sure that you're responding. Okay, so having reviewed the statutory framework, let's kind of do a miniature case study with a request for all call recordings, because as I mentioned, this recent trend has kind of been triggered by one plaintiff's firm who has been just basically inundating the market with QWRs that are very broad as a whole. They'll include, like, you know, 20, 25 individual requests for information as a whole, extremely overbroad. But then there's discrete requests within there for certain documents that are probably legitimate requests. And one of those requests is for call recordings. And there's been a widespread industry response that, and this is, I think, has been a policy for a long time with respect to call recordings. A lot of clients have taken the position that they are confidential, proprietary, or privileged. That's something that clients have pushed in discovery disputes. It's been a motivating factor to try to get protective orders in place when producing call recordings. So in any event, one of the bases for, these QWRs come in, they request all this information, including the call recordings, and the response from the industry has been, okay, well, you know, we'll provide the transaction report, we'll provide the note, the deed of trust, we'll give you some information. But then they stop short of producing call recordings. And that has generated quite a few lawsuits, primarily putative class actions that are at various stages. Some have settled, some are at motion to dismiss. But the gist of those complaints has all been that the call recordings are available. They're in your databases. You can pull them and produce them. And to refuse to, based on asserting an objection that they're confidential, proprietary, or privileged, is completely improper and subject to the remedies under RESPA. So that's the backdrop for them. So kind of taking a quick analysis of these requests, I mean, the first step is very easy. I don't want to belabor the point. Is it a valid RFI? Does it include the loan number? Is it to the designated address? Is it within the scope of the statute? The last prong is probably the most complicated issue, because what I discussed a few minutes ago regarding the scope of a QWR under RESPA is much more narrow than what the scope of an RFI under Regulation X is. And there's a split of authority on whether or not that more narrow definition applies to both. But assuming that we've got a valid request for information, then the next step in the analysis is, okay, are the call recordings available? And I think the short answer is maybe. It just depends on the accessibility of the recordings and your systems of record. I included here the official interpretation from CFPB that's included in the regs. It uses call recordings actually as an example of something that is available if the servicer's personnel have access to the call recordings in the ordinary course and can locate the correspondence through reasonable business efforts. I mean, that's kind of jam-packed, but my takeaway there is, like, if your systems allow you to do it and your employees of the servicer can do it, then most likely they're going to be available. So let's move on to the next step then, assuming that they are available. The objection, that's kind of the key objection, at least the issue in the litigation, is whether or not they're confidential, proprietary, or privileged information. Having looked at this and thought about this quite a bit, just my personal takeaway is probably not. You know, a recording of a conversation with that customer, it's hard to argue, I think, that that's a confidential communication when you're producing it to just that customer. Now, sure, if some other customer is requesting it, you know, if you're asking for all call recordings with respect to your neighbor's loan, then that's probably a very legitimate reason for refusing to produce the documents. But in any event, so the second thing is that the CFPB has identified call recordings as an example of one type of info that might be available. That's what we just talked about a minute ago. So the inference there is that the CFPB thinks that they are not confidential, proprietary, or privileged. Finally, there's the California Invasion of Privacy Act, which requires, you know, the call disclaimer that your call has been recorded for monitoring or training purposes. excuse me. And the fact that the servicer is disclaiming that your call is being recorded and it's not a private communication kind of undercuts the whole argument that it would be subject to a confidential, proprietary, or privileged information defense. But that's not to say there aren't other exclusions that might be applicable to cut down on either producing recordings, all recordings, or even a subset of recordings. So Dustin, if we can go to the next slide. Some of the other exclusions that may apply, the duplicative or untimely, whether or not the request for call recordings is irrelevant. Now, relevance under Regulation X is described very broadly. It kind of dovetails with the conversation we had a minute ago regarding scope. So essentially, anything related to the mortgage loan is relevant. So the question there is then, do they relate to the actual loan? Probably. You can only make an argument that under Reg X, they only relate to servicing if there's a payment processing issue, but then you have that whole argument and concept we talked about just a minute ago. The final request or reason for exclusion would be if it's overbroad or unduly burdensome. I've got the definitions there, and in the interest of time, I'm not going to read them. But I think the two factors to consider most with overbreadth is, one, how is the request phrased? Is the customer requesting all call recordings with the customer and any third party regarding the loan? Because that could be potentially a lot more burdensome to track down and produce than a more discrete request that asks for, I had a payment issue 2 months ago that I spoke with the servicer, and I would like you to produce all call recordings, during that 2-week time period or something like that. And then similarly, another factor to consider is the individual facts or circumstances of the loan that the request is being made of. If a request for all documents is being made, all recordings is being made, and the loan is 10 years old and it's been in and out of loss mitigation and there's been all kinds of issues with it, then there could be potentially hundreds of call recordings that need to be produced. Whereas if you have a brand new loan or a loan that's only been around for a couple of years with minimal correspondence, then say there's 5 total recordings, your argument of overbroad or unduly burdensome is going to be not nearly as strong. So let's move on. In conclusion, with respect to a request for call recordings, and the analysis could quite easily extend to other requests, maybe for like servicing notes or other things. How a servicer responds should depend on several factors. It's probably best not to do a one-size-fits-all approach. Those factors have to do with availability, the phraseology of the request, the circumstances of the loan. All of those things are factors to include. It's certainly potentially dangerous or creates liability by having just a one-size-fits-all approach where you have a request for call recordings and you across the board respond with objections based on whether it be the confidentiality proprietary, whether it be overbroad and unduly burdensome, because as we've discussed, the facts of an individual request or the facts of individual circumstances of the loan just frankly may not support that objection, and it could expose you to liability. So Dustin, let's go to the next slide. There certainly are pros and cons of this individualized case-specific approach. The pros, like I mentioned, it probably reduces potential liability, particularly from class action litigation. It creates individualized issues that are not susceptible or make it extremely difficult to certify a class, and it probably reduces potential scrutiny from regulators. The cons, like I referred to, it may be more difficult from an operations perspective. Applying a blanket response is certainly easier, but creating these individualized case-specific responses will require, probably updating policies and procedures, training employees, and because it is an individualized response, it may lead to some inconsistencies with those responses. Finally, just simply producing call recordings, if that's the approach you want to take, it could certainly generate to other claims. That's what we've seen also with, in particular, this law firm that's been kind of sending out all these recent QWRs. With that, thank you very much for your time, and I'll turn it back over.
Thank you very much, Loren. That was very helpful. I'd like to switch gears now to Todd Wulffson to address an issue I know our firm, just as an employer itself, has been giving a lot of thought to, and I know Todd as well. The return to work issues presented by COVID-19 and obviously the Delta variant, uh, uh, giving us a little extra things to think about. So, Todd, please take it away.
Thanks, Richard. Thanks, everyone. Yeah, I wanted to give you about a 12-minute summation of all the COVID-19 issues, which will be fun. So I put obviously more information in the slides than I could possibly talk about. But we're going to do kind of an issue spot for the things that are getting employers sued. And this matters for all of you. There's no, if you have one employee, you need to be complying with all this stuff. And the good news is by the time we get done, 15 minutes from now, the rules regarding COVID probably will have changed. So I can update my webinar accordingly because literally they're changing all the time. For those of you that are familiar with the color scheme that we had in effect a couple months ago, it's all gone. All the physical distancing, all those rules are all gone. However, if you're in a county or a city that has their own special rules, you have to be complying with them. So I'm just giving you the list here for the various counties, but whatever county you're in, check with your county Department of Public Health. Or your county health department, whatever they call themselves. Make sure that you're in compliance with your county because the California rules are different than the federal rules and they're different than the county and the city rules. So let's go to the next slide, please, Justin. So here are the two sites. The best sites for the current standards are the California Department of Public Health. What they're doing is they're showing you the executive orders. They're showing you a lot of the county prescriptions, and then most importantly, it's the OSHA, it's the Occupational Safety and Health Administration. That's the entity that says, if you have employees, here's what you have to do or we'll fine you. And by the way, what OSHA has been doing is not only just doing fines, but if they find you to be severely out of compliance. So for example, you have an outbreak and you don't know what an outbreak is under the new rules, and they call you up about it, they're shutting businesses down. So, we're gonna talk briefly about what you need to do, but as a general rule, you need to be aware of the OSHA rules. So this link here, and then the California Department of Public Health. Let's switch slides, please, Dustin. For all of your employees coming back to work, if they're back already and you haven't done these things, then you need to do it really fast. If employees are coming back, you need to do them in advance. The most important thing is you need to have a COVID response plan. So you have to have a written plan, communicate with the employees, letting them know, here's what we're going to be doing to make sure you stay safe in the workplace. We're going to be checking OSHA regs. We're going to be checking CDC regs. We're going to be checking the county regs. We're going to be doing everything we can to make sure it's as safe as possible. That's both for the peace of mind of your employees, and it's also in compliance with the OSHA regulations. If you don't have a COVID response plan and you have 3 or more people within 14 days that get COVID, and OSHA calls you up and says, hey, can you send us a copy of your COVID response plan? And your response is, yeah, I don't know what you're talking about. They may very well shut you down and say, look, for the next 2 weeks, you need to kick out all your employees and shut down your facility until we can assess whether or not you're able to be reopened. So that's the most important thing. And then make sure, as I mentioned before, that you're complying with all your city and county rules. If you're in Orange County, you're pretty much free and clear. If you're in Los Angeles, there's a whole lot of things you need to be doing. If you're in Santa Clara, if you're in anywhere in the Bay Area, they all have their own county and city rules right now with respect to masking, with respect to physical distancing, with respect to hours of operation, all those things. Make sure you communicate to all of your employees as frequently as you can what the rules are. And if the rules are changing, let them know. If you're, I don't know, if in the mortgage business, you have a whole lot of safety meetings, but you may want to start having safety meetings. It's important to remember that under the new rules, the language that you communicate to your employees is the language you have to communicate to them regarding COVID. This is probably not an issue for anybody on this call. But if, for example, you talk to your employees in English and or Spanish, if you provide a COVID notice, it has to be in the language that will be understood by the employees. So you can't just give a written notice anymore. You have to verbally tell the employees in the language they'll understand that there's been a COVID case, for example, in the workplace. Let's go to the next slide, please, Dustin. The new emergency temporary standard came into effect in mid-June. It replaces the one that was in effect from November of last year. And I'll give you just the highlights. And the highlights are the issues that are causing employers the most concern. You have to have face coverings or masks for employees that are unvaccinated, which means you need to know which employees are unvaccinated. As a general rule, you should probably send out an email to all your employees and say, All you want to do is say, we just need to know for purposes of compliance with California law whether you are vaccinated. You never want to ask them why they're not vaccinated. So the question is, are you vaccinated? And if so, when were you fully vaccinated? Fully vaccinated being the date you got your J&J shot or the date you got your second Pfizer or Moderna shot. That information you need to confirm. Either you can do a self-attestation by the employees, which I don't recommend because employees lie, or you can look at their Vax card. Don't keep a copy of it. So tell your employees, look, send me a copy of your Vax card, and we're going to delete the picture after you send it to me. But you want to be able to confirm that the employees, that you have 80% vaccinated employees, because it matters for a lot of the compliance issues with this. Any employee that is not vaccinated has to wear a mask in the workplace. Mask standards have been updated. People cannot be wearing a bandana. They can't be wearing a gaiter. They can't pull their t-shirt up over their face anymore. They have to be wearing a cloth face covering, which is stupid because cloth face coverings have been completely worthless since day one. But the rules are cloth face covering, surgical mask, or an N95 mask. You need to have N95 masks, and those are the ones that make you look like a duck, the white thing that sits on your face. They actually do something. By definition, they keep 95% of all particulate matter out of your lungs. Those have to be made available to employees that are non-vaccinated if they want to wear them. You don't have to make them wear N95 masks, but you have to have them available if they ask for them. And then if you have an outbreak, which means you have more than 3 cases within 14 days, you got to have everybody mask up. And every employee can request an N95 mask from you. You can't just say, oh, go buy one and we'll reimburse you. You have to have them available for employees that are in the office. If they're working remotely, obviously none of this really matters, but you need to have those available. If you have a case in the workplace, what the rules were before is you had to, talk to the individual employee, find out, when they had their first symptoms. All that's out the window. If an employee right now reports that they're positive, what you need to do is you need to do contact tracing. You need to ask them, who have you been in close contact with? And close contact is within 6 feet of another employee for more than 15 minutes, whether or not they're wearing a mask. Find out that list of people, and then find out the list of people that are in the area that shares wall space with them. So if they're in a cube farm sitting in a room, everyone in that room, you need to know about those as well. Everybody in the facility, or everyone who shares air with the person who has contracted COVID, needs to be informed that a COVID-19 positive case was in the facility. You don't ever give the person's name of the person that's infected. If you want to go get tested, we'll pay for it. If you want to have a mask, we have them for you. And anyone that was in close contact, again, within 6 feet for more than 15 minutes, they have to be excluded from the workplace for the next 14 days. Your employee has to go out as well, and they have to be gone for at least 10 days from the time that they're positive. You cannot require them to have a negative test to come back, but if they go get a negative test, which is highly unlikely because you usually test positive for weeks after you get over the symptoms, if they do get a negative test, they can come back. You can't require it, but otherwise they have to go out for at least 10 days after their diagnosis being positive. And again, all the other employees have to be excluded for 14. And all that notification to your employees has to be in the language that you normally communicate with them. So if you've got employees that speak French or German, then that's your language. Next slide, please. So all the testing rules from before really get boiled down to if you have a COVID positive case in the workplace, you need to advise all the employees that share air to go get tested, and you're going to pay for it. If the employees want to go get tested or they want to go get vaccinated, you need to pay them for the time doing that. If you tell an employee that they have to go get tested, then you obviously have to pay for that. You have to pay for the time involved in doing it. And we'll talk a little bit about mandatory vaccination policies. But anytime you tell an employee to go do something, you got to pay them not only for the cost of doing it, but the time involved in doing it as well. And again, an outbreak under the new rules, if you have 3 cases within 14 days, everyone has to mask up. Everyone has to be told to go get tested. That's including the people that are vaccinated. And you need to tell everyone if you are experiencing any symptoms at all, let us know immediately. Because if you have an outbreak, you got to report it to the local county public health department, and they're going to monitor you, and they're going to make sure that you're doing it all correctly. And if you don't, they'll shut you down. Next slide, please. All right, let's talk about vaccines really quickly. A lot of people are saying, oh, great, we're just going to have a mandatory vaccination policy. That's fine, except for the fact that it's going to get you sued. You cannot mandate vaccines in California for all of your employees. I don't care what you see on the news or anywhere else, you can't do it. You have to allow accommodations for medical conditions, disabilities, and sincerely held religious beliefs for people that can't be vaccinated. You can ask for documentation, and the typical documentation is, my patient is under my care and she is not able to be vaccinated. That's enough. Don't argue with them over what the issue is. And don't have it be, we need proof that you can't be vaccinated. Have a situation in your COVID response plan, tell the employees, look, if you're uncomfortable with being vaccinated for medical reasons, come talk to us. Because if you have a mandatory vaccination policy, the people you're going to wind up precluding from the workplace are people with medical conditions where they're scared or their doctor said, well, maybe it's not a good idea to get a vaccine. It's not that they can't do it, but they really shouldn't. And the other group of people you're going to be excluding are pregnant women. I've seen dozens of notes from doctors saying, I'm not going to say that a pregnant woman can't be vaccinated. I'm just going to say it's not advisable because keep in mind the vaccine is not approved. The FDA has not given it its blessing. It's been approved on an emergency basis only. It's an untested mRNA, so messenger RNA vaccine. It's never been used before. We have no idea what it's going to do to a developing fetus. And a lot of doctors, the vast majority of them are saying, if you can avoid being vaccinated, it's probably a good idea. And if you have an employee that says, here's a note from my doctor saying that, she or he advises me not to get vaccinated, that's good enough. The religious, sincerely held religious belief is a huge problem right now. There literally are sites on the internet where you can go and you can do a $5 donation and you can get a letter from this internet church that says you can't be vaccinated. It's complete crap. So if you see one of those things, don't allow it. I'm not saying you should invite a lawsuit, but if you want to have a mandatory vaccine policy, you need something in writing that identifies the individual and says, Jane Smith is a member of my congregation, and under the edicts of our religion, vaccines are bad, or we don't allow them, or something like that. It can't be something they printed off the internet. It can't be something they've obviously paid for. It needs to be, something directed to that individual employee. And my statement to all of you is anybody that wants to call me, and I don't bill for phone calls anyway, and send me one of these things, I'll help talk you through it, because I've seen probably 60 or 70 of these things now, and they're ridiculous. You pay $5 and you get this printout on the internet. So keep in mind, if you do a mandatory vaccination policy, you're going to wind up administratively hampering yourself. You're going to have whoever's in charge of your HR talking to all of your employees about all the medical conditions you never wanted to know about, all the disabilities they think they might have that you never wanted to know about, and you're not going to have a record of all of your employees telling you all the maladies they have that keeps them from being vaccinated. So I still think it's a much better plan, and let's go to the next slide, please. I still think it's a much better plan to strongly encourage vaccinations as opposed to mandating them. But Google just said all 140,000 employees need to be vaccinated. All healthcare workers in California need to be vaccinated. But if you're watching the news, you're seeing that there's some serious problems with mandatory vaccination policies, and it creates a real administrative burden for employers. And if you're a small employer, I don't recommend you doing it, particularly if you got employees that are working remotely. And oh, by the way, you can't impose a mandatory vaccination policy on your employees that are working remotely. I've already got 2 lawsuits on that. And the client said, well, it's for the betterment of all society, right? We want all of our employees to be vaccinated. Yeah, they never come into the office and we never see them, but we want to mandate they be vaccinated. That's ridiculous. You can't do that. And keep in mind that if you've got employees that are vaccinated and the people that are unvaccinated, the unvaccinated folks need to wear a mask. So California is forcing that discrimination on you, but otherwise you can't treat employees differently because they're unvaccinated. You can't say, well, you're not going to be able to work on these matters, or you can't travel, or you can't work with these clients, those types of things. That's overt discrimination based on their medical condition, and it'll get you sued. If you have a client or a customer that says, we won't let anybody in the building that's not vaccinated, okay, that's fine. That's not you discriminating, that's your client. But don't you as the employer impose those kind of burdens, and make sure that employees understand, particularly managers, you can't go around interrogating people as to their vaccination status. So if a manager comes up to your employee and says, hey, I noticed that you're not vaccinated. Why? I mean, what problem do you have with the vaccination? That's illegal on its face. Your manager has now created strict liability for you as the employer, and you can be sued for harassment, retaliation, and/or medical condition discrimination. So make sure everyone understands that that's true. And as an aside on this whole thing, any information you have regarding your employees relative to COVID or their vaccination status, whether it's a temperature check, or whether they answer the questions walking in the door, or reporting to you with their vaccination status, that all is confidential medical information, has to be kept in a confidential separate folder from their personnel file and can't be divulged to anyone except those that have a need to know. And people that are need to know are basically the owners, whoever's in charge of HR, and maybe the facility manager at that particular site. Let's go to the next slide, please. Foreshadowing for what I just said. And in California, we've got the California Consumer Privacy Act, and to follow on what was before, class actions on this issue are huge. You're not going to just get sued over requests for call recordings or disclosures, things like that. You're going to get sued because you have one employee who hooks up with a lawyer and decides that you requiring them to turn in their physical vaccination card and you keeping a copy of it is a violation of their rights. They're probably right. Class action, it's a cottage industry right now. And in California, keep in mind that you don't have to have a class action. You can have what's called a Private Attorney General's Act claim. And if you violate some labor code provision, like keeping your personnel file confidential, they can sue you for the penalties on behalf of all employees you've had within the last year, and a class action is within the last 4 years. So make sure you keep everything private. Next slide, please. This is the last slide. So here, just a quick recap on what the trending issues are. There is a running, I mean, we got rid of the whole fear of COVID thing by saying, well, everyone's getting vaccinated, so come back to work. Now everyone's saying, I'm afraid of the variant, or the super variant is what they're calling the new one. It doesn't qualify as a disability unless, of course, you have a doctor saying, I'm treating this patient for, some kind of COVID phobia. Treat that as legitimate. There are some people out there that, it depends on what news station you watch, really depends on what your fear is of this variant. But people that are vaccinated are getting scared of the variant, which is really upsetting. But people can't just refuse to come back to work if everyone else is coming back to work. But if you can allow people to work from home, or you can work out an accommodation, it's probably better to do that for morale purposes as well as the legal issues. But there really is no legal claim now saying that, yes, I'm vaccinated, but I don't want to come back to work because I'm scared of this variant. Mandatory testing, we talked about, is a huge nightmare. If you're going to do it, do not implement a mandatory testing policy unless you've got a lawyer with a really good malpractice policy that has looked at that vaccine testing policy or the vaccine mandatory policy for you in advance, because chances are there's going to be a lot of problems with it. And keep in mind that you're going to be excluding pregnant women. You're going to be excluding people with medical conditions. There's a lot of people, for example, that are going through chemo cannot get the vaccine. And I don't know if you want to have people recovering from cancer that are going to be excluded from the workforce because you want a mandatory vaccine policy. All information needs to get kept private. And wage and hour issues, two things I want to mention. If an employee shows up and you have some kind of a screening policy, or they got sniffles or coughing or whatever, and you say, hey, are you feeling sick? And they say, yeah, I'm feeling sick. Well, you need to go home. If that person's non-exempt, so they're an hourly person, you got to pay them for showing up. I know it sounds really stupid, and it really is stupid. But show up pay in California is a minimum of 2 hours, maximum of 4 hours. Otherwise, it's half of their shift. So if someone knowingly shows up to work sick, knowing you're going to send them home, you have to pay them at least 2 hours of work. Sorry, it's California. We have good weather. And then the other issue with respect to if they're spending time waiting in line, being screened or having their temperature taken, whatever, all that time spent waiting around in line, you need to pay them for it. If they go get a vaccine because you've told them they have to get a vaccine, you have a mandatory policy, you have to pay them for all of the time associated with getting that vaccine. And you need to tell them, hey, go to the clinic down the street, because otherwise they can drive to Riverside and charge you for 6 hours there and back. And there's nothing you can do about it. And finally, if you've got employees that are still working at home, if they voluntarily work from home, you can get around a lot of the otherwise reimbursable expenses. But if you're telling them, look, Monday, Wednesday, and Friday, I want you in the office, Tuesday and Thursday, you're assigned to work at home, the increased costs of their electricity from home, from their internet usage at home, and all the other things that may be pennies, you need to reimburse them for that, or you need to have a policy that says, if you believe you're incurring extra costs, please submit it on an expense report and we'll pay you for it. Otherwise, you're setting yourself up for a class action, and there's about 50 of them rolling around California right now for home-based expenses that aren't being paid, and it's pennies a day, but it's the attorney's fees that drives these things. It's not the actual money. So with that, I'll save it to the end if there's any questions.
And thank you very much, Todd. And now we'll turn it over to Reid and Sandy to address servicing issues regarding COVID-19.
Good morning, Sandy Shatz, McGlinchey, Stafford, and we wanted to share a few thoughts. When the pandemic hit, the agencies erupted in a volume of regulations and guidance, including mortgage foreclosure moratorium. As the pandemic was coming under control and things were winding down over the summer, the moratorium were going to end. We thought they'd end June 30th, and they were extended till July 31st, and they've now all ended, or have they? I just want to share a few thoughts. Under the CARES Act, it's a milestone foreclosure moratorium where a servicer may not initiate a non-judicial or judicial foreclosure, move for a foreclosure judgment or order of sale, or execute a foreclosure-related eviction or foreclosure sale. Fannie and Freddie took opposite approaches. Fannie copied the language of the CARES Act and adopted a milestone approach. Freddie did a process approach where servicers must suspend all foreclosure actions, including foreclosure sales. We note that difference. Next slide, please, Dustin. The three federal agencies, VA, USDA, and HUD, did different things. VA and USDA did milestones. HUD did a process where all foreclosures were held up. If you're not just in California, remember to check state law. And while California doesn't have a foreclosure moratorium, they did issue guidance on April 9th concerning foreclosures. So why do we mention this if all of this guidance expired July 31st? The reason we mention this is that the pandemic numbers are increasing, hospitalizations are increasing, things are looking worse, and it is extremely possible that the federals will act again, and we'll see the moratorium come back in place. And if so, it's important for servicers to be able to differentiate between milestone moratorium and process moratorium. Next slide. We also had an OCC eviction moratorium that ended. It ended on July 31st, and it ended in the face of court cases saying the CDC doesn't really have the authority to issue a nationwide eviction moratorium. And in fact, a Supreme Court Justice, Kavanaugh, said, don't really like it, but it's expiring and it's helpful right now, so we'll leave it in place for 30 days until July 31st. But as the Justice said, last three lines, in my view, clear and specific congressional authorization via new legislation would be necessary for the CDC to extend the moratorium past July 31st. Okay, the moratorium is over. Well, next page. The president looked to Congress. Next slide, please, Dustin. Congress tried to act. They introduced a bill and it failed. So then Congress looked to the president. President said, I can't do anything. The CDC read the tea leaves and passed an eviction order. There is now an eviction order that is limited to renters. That is, if you have a multifamily loan and you have renters in your property, it may apply to you. It doesn't apply to foreclosure evictions, has income limits, and it expires in 2 months. A borrower must prepare a declaration stating they are affected by COVID and they have been unable to obtain other assistance. And if that's the case, eviction moratorium. Will that hold up? Next slide. In my view, it's unlikely. New York had 2 eviction provisions in their law. One of them was self-certified, Part A, by a borrower, where the borrower says, COVID, 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 can't evict me. Here's my declaration. The other part was, I have COVID issues, Part B, and a court decides whether or not the eviction can proceed. The Supreme Court, in one of its shadow orders, on August 12th said, no, the part where the borrower self-certifies, since there's no court review, is self-enforcing, and that's not the way it works. People can't be the judge and jury of their own case. we're going to enjoin that order. That's likely the way the CDC order is going to go. It's possible Congress may act, but right now there's a CDC eviction order in place. So next slide. What do you need to know? Foreclosures right now can proceed and go forward until we talk to Reid. And while they're proceeding and going forward, please check your statutes of limitation, continue to reach out to borrowers and triage. All of the agencies, investors, and owners want you to work with your borrowers to see if there are alternatives to foreclosure. Since most borrowers can do something to avoid foreclosure, it's worth it. But where borrowers cannot, then yes, you must foreclose. Remember, Fannie and Freddie are paying a bounty if you start the new foreclosure process. Forbearance, next slide, is still possible under federal law. If a borrower in a federally backed mortgage seeks forbearance, they can get it. Pre-pandemic, forbearance was at about 0.25% of all loans. It rocketed up in the first 3 months to 8.55% of all loans, and it's been coming down for the last 22 weeks. To the current level of 3.26% of all loans are in forbearance. I put the numbers up on the screen so you can see how they're going. Next slide, please. Who's in forbearance? The people in forbearance, about 10% of borrowers are in the initial term in the first 6 months. 83% of borrowers are in an extended term, meaning they're in forbearance for 6 months or more. Of those borrowers who are leaving forbearance, a quarter remained current the entire time, a quarter took a deferral, a quarter either reinstated, modified, or sold their property or refinanced. However, 16% of the borrowers have no plan and they left forbearance, perhaps because it expired, perhaps because they're losing our home. Those are the borrowers that we should be focusing on, how to help them or foreclose and help them find a non-possessory solution. What Fannie and Freddie found, next slide, in the case of Fannie, they're finding that most of their borrowers who started in forbearance, 1,400,000, have either left forbearance or done some type of deferral or plan, or obtained an old style loan modification. About 2% of those borrowers are getting the traditional loan mod, finding the same thing on the multifamily side. Freddie, the next slide, is showing similar things. Most of their borrowers who entered forbearance are doing things that are current, either paying off the loan or getting a deferral, but they are not using traditional loan mod stuff. It's kind of fun that we're having new things to help them here. Will forbearance last forever? Next slide. Forbearance under the CARES Act is available during the covered period, which is undefined. Fannie and Freddie say it's open for now. There is no end date on it. If you have a Fannie or Freddie loan, give it to a borrower. The other agencies say you must apply by the end of next month and it must expire by June 30. I think that's an area for litigation because the CARES Act doesn't put those restrictions on it. However, from all agencies, the key is for servicers, reach out to your borrowers. So what do you need to do now? Next slide. Well, we have forbearance. It's still available. Reach out to your borrowers. The Bureau has new rules on what you do once you reach your borrowers. We'll talk about that in a minute. But the key here is outreach. As we approach the ability to actually foreclose and or the end of forbearance, the key is get hold of your borrowers, see what you can do. If you can help the borrowers, do so. We have lots of plans. We'll talk about a few of them now. If you can't help your borrowers, let's find a non-possessory solution. Reid, what's the Bureau saying?
Yeah, thanks, Andy. So I'm going to talk today about first the Cfpb's mortgage servicing COVID-19 final rule, and if we can go to the next slide. Just a bit on the scope quickly and the effective date. It was released on June 28th, and it amended Reg Act in a number of ways to affect servicing and loss mit for COVID-19 affected borrowers, but also the broader market. Now, it was published in the Federal Register on June 30th and then had an effective date of August 31st, which was a necessity from an administrative law perspective because it constituted significant rulemaking, and they couldn't make it effective earlier than 60 days after the publication date. Issue is prior to the final rule, as Sandy noted, the CDC, FHFA, FHA, VA They all extended their foreclosure moratoriums only until July 31st, so we had a 1-month gap between these, these protections. And to address the issue, FHFA announced just we're gonna impose these protections from the final rule early, 1 month early, to bridge this gap, which was then implemented by Fannie and Freddie. But back to the final rule, the scope is just the scope of loans that would otherwise be subject to 1024.41 and the early intervention rule under Reg X. So it's closed-end, federally related mortgage loans secured by the borrower's principal residence. This is broader than the CARES Act, which was federally backed mortgage loans, i.e. agency and GSE loans. So essentially the foreclosure protections are a broad moratorium with a few slightly helpful carve-outs, which I'll talk about. And I'm going to talk about the main aspects of the rule over the next few slides, if we can move the deck. The first, temporary foreclosure protection safeguards. Obviously, enhanced protections in effect from August 31st in light of the earlier implementation, all the way through December 31st of this year. There are some exceptions to the applicability. Obviously, they expire on December 31st of this year, so they don't apply to a foreclosure referral on or after January 1st, 2022. At that point, the borrower just has to be 120 days delinquent as they would under existing law. There's also an exception if the borrower was more than 120 days delinquent prior to March 1st, 2020. And finally, there's an exception if the applicable statute of limitations for the foreclosure actions is going to expire before January 1st, 2022. But then back to the actual foreclosure protections. Now, while this rule is effective through the end of this year, you can't refer a borrower to foreclosure. And when I say refer, it's the first notice or filing under Reg X to commence the foreclosure due to missed payments. So the avenue that lets you foreclose or commence if they're 120 days delinquent or more than that, unless one of 3 additional what they call temporary safeguards have been met. Procedural safeguards. So first, we have a complete loss mitigation evaluation. You can move forward commencing the foreclosure. The borrower has submitted a complete application. The borrower has remained delinquent at all times since they submitted the application. And then that evaluation process that's contemplated under Reg X has been exhausted. And so whether it's exhausted simply refers back to subsection F2 that allows you to proceed with foreclosure if the borrower did not qualify for any loss mitigation options and they've exhausted the appeal process that's available, or the borrower rejects all of the loss mitigation options offered, or say the borrower fails to perform under an agreed upon loss mitigation agreement. Second, we have abandoned property. You can move forward with a foreclosure referral if the property has been abandoned pursuant to the laws, pursuant to a definition of abandoned property in the laws of the state or municipality where the property is located. And finally, we have an exception or an avenue for unresponsive borrowers. You can move forward with foreclosure if certain requirements are met to establish that the borrower is unresponsive during a 90-day period prior to the foreclosure referral. Now, to meet this requirement, first, the servicer must not have received any communications from the borrower during that 90-day period, and the servicer has to meet several conditions: that they made a good faith effort to comply with the earlier intervention live contact requirements existing under Reg X during that 90-day period. They have to have sent a written early intervention notice between 10 and 45 days prior to the foreclosure referral. The servicer has to have sent all required loss mitigation notices during that 90-day period. And the borrower's foreclosure plan, if they were in one, must have ended at least 30 days prior to foreclosure referral. And one important thing to note, the commentary has some specific record-keeping requirements for servicers if they proceed under these new avenues or procedural safeguards or whatever you want to call them. And so, for example, they describe the records that have to be retained to evidence that the borrower never communicated with the servicer despite all the efforts described above. So some of these are tricky. I mean, the procedural safeguards kind of seem cut and dry on first look, but there are some challenges and some sort of tricky nuance built in if you decide to proceed on these grounds. At a very high level, if you proceed with foreclosure using one of these exceptions, I think you should expect heightened scrutiny from the CFPB, not just on that exception to foreclosure protections, but how the loan was serviced overall. I'll talk about quickly some of that compliance guidance later on. So take, for example, the complete loss mitigation application exemption. If you foreclose under this exemption, you obviously need to be very confident that the application was handled in strict compliance with Reg X. But one interesting question is how all that regulatory flexibility that the Kraninger era CFPB announced last year in the April interagency statement and the FAQs would apply in this context. So those are the ones that said, oh, well, we know you're overburdened with COVID. You don't have to send an acknowledgement letter on time, and you can get some leeway for the 30-day evaluation notice, all that stuff. Those are still technically in effect, but despite that offering, I mean, there may be some negative scrutiny if, say, you issued loss mitigation notices on the subject application later than what is expressly required under Reg X. And as I'll touch on later on, the Biden era CFPB has in several ways signaled limitations on the availability of those regulatory flexibility offerings from the April 2020 guidance issuances. Then we can look at abandoned properties. This is kind of tricky, and it's critical to understand the nuance of exactly what this is versus concepts like whether the whether the property is the borrower's principal residence, and so not subject to these provisions at all, or whether the whether the property is vacant, which itself is not a criteria under any of these provisions. It's an abandoned property definition and principal residence. Whether it's just vacant isn't necessarily impactful or determinative. So those are three very distinct concepts that can very easily be blurred. The unresponsive borrower prong. So there are some inherent difficulties here with determining they're unresponsive under these criteria. I mean, it can be a challenge to be sure, and very confident and to document that you didn't receive any communications during this 90-day period. Often as Loren talked about earlier, servicers will designate an address for their notices of error or their information requests. And if they're sent to the wrong place, you're not necessarily bound by the timing and response requirements. Can you rely on that kind of process here? Not clear. What if the borrower sends it to an inappropriate PO box? What if they walk into a branch or call a branch and communicate with someone on their loan who doesn't properly note or escalate it? Those are all things that are concerning and need to be considered before you apply these exceptions. Moving on to the next slide, I'll talk about the Streamlined Loan Mod option. So this is just a new exception to what's called the anti-evasion rule, where you can't offer loss mitigation based on an incomplete application. They want you to get a full application and review them for all available options. This is similar to that interim final rule last year, which was essentially tailored to allow the Fannie Freddie deferral options or the FHA partial claim. Now it's further expanded for additional COVID loan mod options. It's pretty broad. They have, you can offer a loan mod based on an incomplete application if various criteria are met. Can't extend them more than 40 years from the date the modification is effective. Can't increase their monthly principal and interest payment. If amounts are deferred, you can't accrue interest on those. Pre-existing delinquencies have to be cured. And then, you can't charge any fees for the loan mod, and you have to waive certain fees that the borrower owes that were incurred on or after March 1st, 2020, like late fees, penalties, and that kind of thing. And that was helpful clarification, that last point. So these are pretty broad criteria and just meant to cover the post-forbearance streamlined options. And for example, unlike the interim final rule, it doesn't do things like prevent the servicers from capitalizing forborne payment amounts. So it's a helpful measure. Moving on, I'll talk about early intervention, live contact, and reasonable diligence, which are the two quick other items. Now, from the effective date to October 1st, when you engage in live contact, you just have to convey certain COVID-related information. There's specific content if they're not currently in a forbearance program, to describe the options and what they have to do. And then if they are in a forbearance program, you tell them what the end date of that is, and you describe the available loss mid options that explain how they can apply to them to become current. Reasonable diligence, there's some clarification as to what reasonable diligence measures you have to engage in if a borrower is in a COVID forbearance program. No later than 30 days prior to the scheduled end date of the forbearance, you have to determine if they want to complete a loss mid application. And then you have to engage in reasonable diligence to get them to complete it prior to the end of the forbearance, essentially. Moving on to the next slide. I'm not going to spend much time here, but we have a quick description of the post-forbearance loss mid options available from the GSEs and from the federal agencies. Notably, the federal agencies completely revamped their COVID options at the end of July in response to the final rule. If you look at FHA for example, they had the COVID-19 advanced loan mod option in mortgagee letter 2021-15, and then on July 23rd they had they issued the recovery standalone partial claim and the recovery mod, and that was in mortgagee letter 2021-18, and those new options replaced that waterfall that was issued last summer by the FHA. That was kind of problematic under the interim final rule that was issued like a week before it. But that's it there. And moving on to the next slide, we don't have obviously time to talk about all this, but some of the priority, focus from the CFPB. It's obviously on post-forbearance relief and foreclosure protections. Get very familiar with Compliance Bulletin 2021-02, and then the very recent CFPB report on mortgage servicer performance. I note there's a sort of a tricky gotcha in the Compliance Bulletin. They didn't really make it clear in the body of the bulletin, but the press release says, provided that servicers are demonstrating effectiveness in helping consumers in accordance with today's Compliance Bulletin, the CFPB will continue to evaluate servicer activity, continue with the joint statement. Yeah, I won't read the entire title, but they'll continue to allow the kind of regulatory flexibility that I mentioned earlier for the timing requirements of various notices. And this is reaffirmed in the preamble of the final rule too. So they're saying, yeah, you can get some regulatory flexibility on the timing of these notices, which you've maybe been doing for the last year and a half, but we're only going to still allow that if we otherwise like your overall performance in helping COVID-affected borrowers, which obviously a bit of a gotcha there. And that's all I had, and I'll go ahead and hand it back to Sandy for more content.
You're muted, Sandy.
The two thoughts are that slide and the next slide. Dustin, there is money available to help homeowners under both the Homeowner Assistance Fund, next slide, and the Emergency Rental Assistance Fund. If your borrowers or tenants are having trouble making their mortgage payments and you don't have a plan, there is $46 billion in federal money available. Of the $25 billion money under the Consolidated Appropriations Act plan, only $3 billion has been given out as of 2 weeks ago. So there is hope available beside foreclosure. Next slide is lessons learned. Okay, well, big picture, primarily outreach, less paperwork, work with the investors, and reach out to borrowers because some of them want to keep their home, and if not, find another solution. Thank you all for coming, and Dustin, back to you.
Thank you very much, Loren, Todd, Sandy, and Reid. Very helpful, a lot of content. Dustin, I think if people have questions, so they just send them on to you, and then the appropriate person will follow up.
Absolutely, yeah, you can do that since we're out of time.
Very good. And again, thank you very much. Hope everyone attending has a pleasant remainder of their day. Bye now.
Thanks.